Hi, I'm going to talk to you about how to make a successful bail application in court. What is bail, and how do you make a successful bail application in court in New South Wales? If you or your loved one's been arrested and charged by police, it will be a very difficult and distressful time. The arrested person, also known as the accused, will then be put into custody on remand until the case is finally determined. That can take months to years depending on the seriousness of the charges. Unless the accused person's been granted bail, the first thing that needs to be done is to make a bail application to get out on bail as soon as possible. If bail is granted, the accused person will be released on bail in the community on conditions, at least until the case finalises. If bail is refused, the accused person will remain in jail on remand until the case concludes. New South Wales laws allow only one chance at making a bail application in court. Because of that, it's critical to make sure it's done properly by an experienced bail lawyer. The law doesn't let you make a second bail application in the same court unless you weren't legally represented, or circumstances have changed, or new material evidence has come to light. Instead of making a second try at bail in the local court, you may have a higher success rate at a Supreme Court bail application heard by a Supreme Court Justice. You can only make a Supreme Court bail application if the local court has already refused bail after your first attempt at making a bail application. How to get bail at court? The court will grant bail if you're able to convince the magistrate or judge that the show cause test and unacceptable risk test are both satisfied. The show cause test will be satisfied if you can show enough reasons backed with evidence that continued imprisonment is not justified during the court proceedings are on foot. The unacceptable risk test will be satisfied if you can show enough reasons backed with evidence that there is no unacceptable risk associated with granting bail, regardless of the fact that the court has concerns that the accused person will not appear in court, commit a serious offence, endanger or interfere with the alleged victim, witnesses or evidence. The show cause test is only required to be considered by the court if it's a show cause offence. Otherwise, the court will go straight to considering the second test, being the unacceptable risk test. Now, a show cause offence is any criminal charge that has a maximum penalty of life imprisonment, or a serious offence, a sexual offence involving firearms, or a serious drug offence, where the accused person is charged for a serious offence while on bail or parole, or an offence involving wounding or grievous bodily harm, where he or she has a previous conviction of a serious personal violence offence in the past. When convincing the court to grant bail, an experienced bail lawyer should thoroughly prepare the bail application, conduct a prison visit to speak with the accused person beforehand, and as many times as required, point out the weaknesses of the police evidence and strengths of the defence case, and present all evidence to show the accused has strong community ties, has a job, home, family, no history of violence, good character, the need he or she has to be free on bail, and solid proposed bail conditions, including a bail surety. So what kind of bail conditions can be imposed? A court will impose bail conditions that are required to directly address specific bail concerns. A court can impose numerous bail conditions, including reporting certain days of the week between certain timeframes, security condition requiring acceptable person deposit or agree to deposit a sum of money or security to the court as a surety for bail, a character reference from a referee outlining whether he or she considers that the accused person is a responsible person likely to comply with the court orders, surrendering passport, residential condition, which requires the accused person to be at home between a certain time period during the day or night, prohibition from attending or going within a certain distance from an airport or ship port, residential rehabilitation, compliance with alcohol or drug tests. For more information on bail applications, browse through our bail page here or call us 24/7 to arrange a free consult with an experienced bail lawyer today, and thanks for watching.